Federico Yorong Jr. of JS Criminology. So for today's video, I will be citing here what are my understanding regarding Article 119, Trial of Revised Rules on Criminal Procedure, including its sections. So to start with, when we say trial, it is a formal examination of evidence before a judge, and typically before a jury, in order to decide guilt in a case or criminal or civil proceedings. Section 1. Time to prepare for trial. The accused will only be having at least 15 days to prepare for a trial. The trial also must be commenced within 30 days from receipt of the pre-trial order. Meaning to say, in preparing a trial, we are only given an ample of the time to prepare for it. Section 2. Continuous trial until terminated. In this section, once the trial commenced, it shall be continued from day to day as far as it is practicable until terminated, and will be postponed if and only if it is reasonable or for good cause. Meaning to say, we can postpone it anytime we want without any valid reasons. In no case shall the entire trial period exceed 180 days from the first day of trial, except an otherwise authorized by the Supreme Court. Section 4. Factors for granting continuance. In this section, these are their basis in considering the court to grant a continuance. A. Whether or not the failure to grant a continuance in the proceeding would likely make a continuation of such proceeding impossible or result in a miscarriage of justice. B. Whether or not the case taken as a whole is so novel, unusual, and complex. In clarification, no continuance under Section 3 of this rule shall be granted because of congestion of the court's calendar. Section 9. Remedy where accused is not brought to trial within the time limit. Whenever the accused is not brought to trial within the time limit required by Rule 116 in Section 1, tendency is that the information may be dismissed on motion of the accused on the ground of denial of his right of speedy trial. Note: unmentioned sections are not included in the discussion. Section 11. Order of trial. The trial proceed the following order. A. The prosecution shall present evidence to prove the charge. B. The accused may present evidence to prove his defense. C. The prosecution and the defense may, in that order, present rebuttal and surrebuttal evidence. D. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision. A. When the accused admits the act or omission charged in the complaint or information but the interposes a lawful defense, these orders must be followed in order to have a proper and a good result for trial. Section 16. Trial of several accused. It is when two or more persons are jointly charged with any offense, they shall be tried jointly unless the court's discretion and upon motion of prosecutor. Section 17. Discharge of accused to be state witness. Under this section, the discharge of the accused would dependent to whatever the witness would say nor admit. In short, the state witness will have the power to witness whether the accused one is proven to be guilty or not. Section 23. Demurrer to evidence. This section best explains if the court may dismiss the action on the ground of insufficiency of evidence. And lastly, for Section 24, reopening. Reopening would be any time as long as before finality of the judgment of conviction. That would be all for today's video. Thank you and have a blessed day ahead.